us all to take our seats and to be sure that we have plenty of time later to talk. And we've already gone through one roll call. I think one roll call was enough. We're missing Ms. Wright. What do we do with Ms. Wright being not present?
Well, thank you. You know she is. She's running.
Okay, we have one member running, so that's good. She'll be here in 10 seconds. By the time I get to her name, alphabetically it's sequential, so it's fine. We've already done a roll call, so I'm going to suggest you don't need one. Is that okay? Or do we need one? We do need one, so Kelly, could you do a roll call, please? Slowly when we get to the end of the alphabet.
I will.
Thank you.
Dr. Bishop?
Here.
Dr. Diego? Here. Dr. Lewis?
President.
Mr. Serrano-Sewell?
Present.
Ms. Wright? Present. Dr. Yip?
Here.
Ms. Yaroslavsky?
Present. Okay, thank you very much. I'm going to turn our meeting over currently now to our administrative law judge, Mr. Benjamin, please.
Good afternoon, everyone. Dr. Jackson, we're going to go on the record in just a second. You're representing yourself today, is that right?
That's right.
Okay, so when we go on the record, I'm going to take a minute and explain the procedures that I'm going to follow today. All right?
Thank you.
All right, we're on the record. In the matter of the accusation and petition to revoke probation against D. Anthony Jackson, MD. This case bears agency number D1 2000 114681. Today is February 5th, 2014. It's almost 2:40. Panel A of the Medical Board is sitting in Burlingame, California. My name is David Benjamin. I'm an administrative law judge for the Office of Administrative Hearing, assigned to preside over this argument today. I'm going to take the appearances, please, beginning with counsel for complainant.
Good afternoon, Your Honor. Deputy Attorney General Margaret Fay on behalf of the complainant.
Good afternoon. And Dr. Jackson, good afternoon to you.
Good afternoon, Judge Benjamin. Anthony Jackson, in pro per.
You're going to represent yourself, as you
That's
said.
correct.
Well, let me tell you my understanding of the background of this case. My understanding is that the board entered a decision in this matter on July 22nd, 2011, and in that decision, the board granted complainant's petition to revoke Dr. Jackson's license and revoked his license. Since then, the Superior Court has granted in part and denied in part a petition for writ of mandate in its review of the board's decision. Specifically, the court found that Dr. Jackson is not subject to discipline based on his July 29th, 2008 DUI conviction, and is not subject to discipline based on his use of alcohol on September 17th, 2007. In its writ, the Superior Court has directed the board to reconsider its decision in light of the court's ruling. That's the purpose of today's hearing. So the purpose of today's hearing is to allow both parties to present oral argument on what level of discipline should be imposed, if any, in light of the court's ruling. We're here today only for oral argument. Arguments must be based on the existing record. No new evidence will be presented or accepted. If you advance facts in support of your argument, you may be asked to cite to the specific portion of the record where those facts were established. Panel members may ask questions as the argument proceeds, but they may not ask questions that would elicit new evidence. So the procedures that we're going to follow are that Dr. Jackson will have 15 minutes to make his opening argument. Complainant will then have 15 minutes to make her opening argument. Dr. Jackson will then have 5 minutes, and complainant will then have 5 minutes. And before you start, let me tell you that I've received some documents that I've divided into 2 packets. The first is a packet almost an inch thick of documents that you've presented, Dr. Jackson. I'm going to mark those documents for identification as Exhibit A. And then I have a packet of documents. I'll tell you quickly what's in them. Complainant's argument, the proposed decision from 2011, the board's decision from July 2011, the Superior Court's ruling from January 31st, 2013, the court's order from the same date, a minute order, December 5th, 2013, a judgment dated November 26th, 2013, the court's writ dated October 31st, 2013, a notice of oral argument for today's hearing, and an amended order fixing the date of today's oral argument. I've marked those documents collectively as Exhibit 1. Have I overlooked anything, Ms. Fay?
Yeah, Your Honor.
Dr. Jackson?
No, sir, Your Honor.
All right, then, Dr. Jackson, you can begin and you have 15 minutes.
Okay, thank you, Your Honor. Ladies and gentlemen, panel A, I am indeed honored and delighted to be here for this hearing. I have waited almost 14 years for this opportunity to publicly view my side of the story. As some of you, or many of you might know, I have literally been at war with the Medical Board of California since 2000. And as you can see today, I'm here representing myself. I don't have an expensive attorney. I think that the truth should set us free. The great Mahatma Gandhi once said, even if you are a minority of one, what's right is right. And I think after I make my presentation that the board inescapably should conclude that the ordeal and the pain and suffering I have experienced at the hands of vigilante justice on the part of the medical board shall, in fact, speak for itself. You know, there's an old Negro spiritual that goes something like this. Somebody please give me just a minute to explain my misery. And believe me, I had an unblemished history up until the year 2000 with the medical board. It was immaculate. I was a very well-decorated and respected physician in my community. I was a role model. I was an advisor to the Honorable Senator Feinstein. I was a spokesperson for the California NAACP. I was an inventor. I was a college professor at the Drew UCLA faculty. And I had never had a complaint, malpractice, no kind of problems with the board. That is until my wife, who co-founded the Brooklyn Medical Group with me, died in 2004. She died from a very bizarre stress-related cancer called OPM, occult primary metastasis. Her name was Betty Henry Jackson. And she was a registered nurse with a master's degree in public health and a healthcare executive. 2 weeks after my wife passed away, for lack of a better word, the ex-director of the Medical Board of California, David Thornton, and his confederate Deputy Attorney General, Sanford Feldman, decided to declare me mentally impaired from bereavement anxiety and a threat to harm patients. And the reason this was done is because I had prevailed in an administrative law procedure in which Medi-Cal had accused me wrongly of Medi-Cal fraud and abuse. Went before the administrative law judge. The judge ruled in my wife and my favor that there had been not one scintilla of proof of Medi-Cal fraud or abuse of substandard care. And he ordered our Medi-Cal funds be released forthwith, which was about $80,000. This was not good enough for Mr. Thornton and his Confederate Deputy Attorney General Sanford Feldman. They usurp what's called judicial absolutism, which is the odious, doctrine that even if you didn't do it, you still did it. That's the mentality of what, I'm not an attorney, but this is my understanding.
Objection, Your Honor. I believe counsel is digressing from what the issue is before the board today.
Well, I'm going to allow Dr. Jackson some latitude in presenting his argument. I think this background on the penalty issue, Doctor?
Absolutely, Your Honor, and you will see when I connect all the dots. Because as the judge, finally, I got some relief from the Honorable Judge Michael P. Kinney, Sacramento Superior Court, who finally recognized that there were extrajudicial motives for the revocation, which he considered it seemed extraordinarily harsh for the circumstances. And that's in the record, Your Honor. But nonetheless, make a long story short, it killed my career. Actually, I'm here. And by the way, I want to just set one thing straight from the beginning. My career as a physician is dead, okay? Once your medical board declares you mentally impaired and a threat to harm patients, and they maintain it on the record to follow the practitioner database for 7 or more years, you're through. I'm uninsurable. I can't do anything with my license. Right? So I'm not really here today to reactivate my license. If anything, I'd like to retire with dignity, but other than that, that's the only purpose I'm here today. So that, please, panel A, be aware of that. Sanford Feldman and David T. Thornton saw to that back in 2004. And by the way, I have some handouts here of David T. Thornton. I think I'd like to pass it around. It is in the record, okay? But it says here, this is in the Sacramento Bee, David Thornton and the California Medical Board, sex scandal, abuse of authority, and racism.
Objection, Your Honor. That is irrelevant to the issue that is before the board.
Well, but this is argument, not the presentation of evidence. But Doctor, here's the thing I'm concerned with. Both parties have a limited amount of time today.
Okay, Your Honor,
And you have about 5 more minutes, and I want to make sure that you get to the end of your presentation rather than being interrupted.
Okay, thank you so much. But anyway, let's talk about the meaning of truth. When I was at the University of Pennsylvania undergraduate school, I took a course in philosophy in which we studied the Socrates-Meno dialogues. And Meno said, "Pray tell Socrates, what is the meaning of truth?" And Socrates described 3 types of truth. Truth number 1 was the concrete, absolute truth, which might be an example of little George Washington when asked by his father, "Did you chop down that cherry tree?" George faintly said, "Yes, I did, Dad." Then Socrates described a tangential type of truth, which says, kind of like, "Honey, does this dress make me look fat?" And of course, tangentially, you better answer that question properly. Otherwise, you're going to have big problems in your marriage. And then last but not least, and most of all, he described what's called an abstract truth. And an abstract truth, Socrates defined as honest ambiguity for goodness sake. Let me repeat that, honest ambiguity for goodness sake. And rhetorically, physicians are faced with those type of questions all the time, where things aren't necessarily black or white. For instance, in the Polynesian culture, the worst thing you can do if one of the patients asks you, "Doctor, am I going to die?" is to tell them the truth. Okay? Probably the most compelling example of abstract truth is Oskar Schindler's List. If it hadn't been for Schindler and his list and his dealing with a tyrant like the Nazis in an abstract, truthful, with an honest ambiguity type of manner, 1,200 survivors would have been lost in their errors forever. So, the medical board would have you think that one of those 3 quarterly, the reason we're here today is because the DUI has been removed, which by the way begs the question, why did they even revoke me for the DUI before I had exhausted my judicial remedies? Especially when the DUI was right at the legal limit of 0.08%. Last but not least.
Doctor, I'm sorry to interrupt, but I just want to let you know you have 2 more minutes.
Okay, last but not least, let's get to the meat of it. The first quarterly report, even though I didn't report it on the actual report, I did 2 weeks later, or actually 2 days later, send an email to my probation officer, and I let her know that indeed that I might have a DUI, but she said, wait and see what the judge says. At that time, I had not been charged. Secondly, on the second DUI, it wasn't a DUI, it was a question of failing to report an incident at LAX airport where my mom died the same day that President Obama was elected, and I went and procured what's called a fake ID, and I told the TSA agent that this was not a governmental issue, everything on it was true and correct, but I had to fly back to Atlanta, Georgia immediately because my mom was going to be cremated. She did not want to be embalmed, and he gave me the choice of waiting for the LAPD to come and clear me or to fly. I chose to wait for the LAPD, and they did not arrest me. They didn't handcuff me. They didn't read me Miranda rights. They took me voluntarily on my own free will to the station to prove who I was. And that's again why when it came to the quarterly report, I answered it with some abstract truth. That in fact, since I was not Mirandized, I didn't consider it a true arrest, and since it was a voluntary detention. Last but not least, all of it was reported and on tape in the third quarterly declaration where investigator Jamie Sandoval put it on tape, and we discussed the LAX incident in detail and at length. At that time, I had not had a probation officer for over a year. There was no one I could communicate with, and I did write a footnote saying, please see Jamie Sandoval's tapes. Everything's included there.
Doctor, I'm sorry to interrupt you now, but your 15 minutes is up. I'm going to come back to you after the Attorney General speaks, and you'll have 5 more minutes.
Thank you, Your Honor.
Thank you. Ms. Beck.
Good afternoon, Your Honor, and board members. It is a privilege for me to be able to speak before you all today. As you know, I am representing the complainant in this action involving the redetermination of the penalty of DeAnthony Jackson. Preliminarily, it should be noted that everything that the board has done up to this date has been appropriate and within its discretion. As you know, and based on the brief you've received, the redetermination of the penalty is based on the second disciplinary action that took place and became effective in 2011, where the administrative law judge rendered a decision recommending revocation that was then adopted by the board and became effective specifically on August 19, 2011. What we are not here to do today is relitigate the first disciplinary action that became effective back in 2005. Nor are we here to relitigate the underlying allegations related to that 2005 accusation. But what is important to note from that 2005 disciplinary action is that it resulted in a stipulated settlement agreement where respondent was in fact represented by counsel and agreed to be placed on a 7-year probationary term and a 240-day suspension, among other things. Now, that probationary term spanned from September 5th, 2005, and was to continue through 2012. It appears that the respondent is confused in his written argument that was submitted to the board by stating that the Superior Court Judge Michael Kinney indicated that there was real doubt pertaining to the events that occurred related to the 2005 accusation. However, he is incorrect. When Judge Kinney in the Superior Court matter remanded this redetermination of penalty issue, he used the terms real doubt to refer to the penalty of revocation based on his decision, which subtracted the DUI and the misuse of alcohol finding from the 2011 action. It's important to note that Judge Kinney also noted that the penalty appeared to be based on all of the adverse actions at that time, which included a DUI, a misuse of alcohol finding, dishonesty, and then the failure to report arrests and convictions. So what is left, essentially, based on the Superior Court judge's decision, is essentially two misdoings, which include dishonesty and the failure to report having been arrested for a DUI and failing to report the possession of a counterfeit license, arrest, as well as the eventual conviction. That all falls under the umbrella of dishonesty. Now, he's also claimed that he has a tripod defense. If two of the legs are removed, the discipline cannot stand, which is also incorrect because there is still a misdemeanor conviction. That does relate to him being able to practice with good judgment as a physician. So there are still some issues and violations of law that did occur contrary to what he was supposed to be doing based on his 2005 action. He was required to obey all laws, and even removing the DUI and the misuse of alcohol finding, he has still violated his probationary terms. And according to the disciplinary guidelines, there is revocation available, and there is a range available, as you know, from a 5-year probationary term to revocation. The decision that was rendered back in 2011 was revocation, and Judge Kinney wanted the board to reconsider or just review the case. Would you still consider revocation if you remove the DUI and misuse of alcohol? And based on our duties as the complainant, what has occurred does warrant revocation. One other thing that I do want to note for the board is that the order was not prejudicial that came from Judge Kinney. It adapts the precise language found in the court's ruling. I prepared it personally. It's neutral. It is not biased. And it was basically the judge's language. So with that said, again, we're just simply asking that you make the proper decision based on the remaining violations of law.
Does that complete your argument?
Yes, Your Honor.
Thank you. Dr. Jackson, you have 5 more minutes.
Thank you, Your Honor. First of all, let's set the record straight. With regards to SSDO, which is a stipulated settlement disciplinary order. All right, that order
Okay, go ahead.
was bullied out of me under the stress and the duress of judicial absolutism, that if I did not sign that order, that mental impairment, which David T. Thornton and Sanford Feldman had put on my record, which was ruining me, murdering my career, would remain forever and a day. And that was actually memorialized, and it's in the exhibits by Attorney Michael Curry, who's an officer of the court, where he talks about the judicial absolutism. They were going to adopt any exculpatory decision, no matter what. And even though I had been exonerated of Medi-Cal fraud and abuse and substandard care, they still maintained that I committed it, and that they were going to do res judicata, collateral estoppel, which is basic double jeopardy, no matter what. And they weren't going to adopt anything. And Your Honor, you're an attorney, and I hope you read that from Michael Curry. So what do you do when you're dealing with a lawless, rogue type of executive medical director? You know, well, what do you do? And by the way, Sanford Feldman and David T. Thornton literally launched a jihad against me. They were hell-bent on revoking me, and they made that patently clear. And my attorney, Albert Garcia, told me so. My probation officer told me so. He said, these guys, whenever they import Sanford Feldman all the way from San Diego just to re-prosecute you, they have a bullseye on your back. Now, again, I have 2,000 lives to take care of, all right, of mentally impaired people who are prone to sudden death. And I'm dealing with a totalitarian medical director who's hell-bent on revoking me. And so I admit, all right, if there was a little latitude where I could disclose it in an abstract, truthful type way in order to keep from being revoked, then so be it. I did it, but it was still disclosed. It was disclosed in an email. It was also disclosed in a footnote whereby it said that please refer to Jamie Sandoval's interview where all of the details of the LAX incident were revealed and divulged. And that's on tape. And last but not least, you know, it's very dangerous, Your Honor, when people start believing their own hype. And, you know, one thing, for 14 years, they have tried to portray me as a Medi-Cal fraudster. All right, even though it says clearly the administrative judge, taken as a whole, okay, the evidence in this case does not constitute reliable evidence of fraud or willful misrepresentation on the part of Dr. Jackson. Yet the DA, the district attorney, her whole argument, it says right in her written arguments, it says written arguments were based on the Medi-Cal fraud and abuse basis for his dishonesty accusations. Now, come on. How can anyone dare accuse and re-accuse for 14 years me of being a Medi-Cal fraudster when it's just blatantly a lie? And this is what I'm up against.
So Dr. Jackson, you only have a minute left, and I think it would be helpful to use that time to tell the board what you think the outcome of your case should be now that the conviction for DUI and the misuse of alcohol are no longer part of the issue, part of the case.
Thank you, Your Honor. I certainly welcome a response to that. I think, all right, that the board should recognize, after all the mea culpas are said and done, that they are at fault too. All right, that's first and foremost. And if anything, they probably owe me a policy. And most disturbing is there's some great people on the board. All right, and when I tell people about this experience, they think that I am a liar. They can't believe it. Great people like Barbara Yaroslavsky, you mentioned her name, and she is held in the highest esteem. And the question is, how could this happen? Who was watching the store when David Feldman, Sanford Feldman, and David Thornton were running around acting like Nazis? Who was watching the store? And the sound of silence is the greatest sin of all. We learned that from World War II. And how can good people remain silent when these type of transgressions are occurring day in and day out? And it's just unbelievable. People can't believe it. And as you know, I'm with the NAACP, AIPAC, and Senator Feinstein and some other folks, and they're appalled. And as a matter of fact, they're also appalled with the unholy alliance between the Department of Justice and the Medical Board of California. It seems like they just rubber stamp anything and everything. And in fact, this so outraged Judge Harry Praterson that he said in the Ninth Circuit, when he overturned that mental impairment disparagement that it took me 7 years and $100,000 to remove, he said, Deputy Attorney General Ostrick, he said, Your Honor, I'm here representing the medical board. And the judge says, not so fast. He says, you are a representative of the people of this state.
Doctor, that your time is up. It sounds like a good place to end.
Thank you, Your
I'm
Honor.
sorry, but your 5 minutes is up.
Thank you.
Thank you. Ms. Gill, you have 5 minutes.
I'm unable to respond to majority of the comments made by the respondent, Your Honor, as I have not been around going back to 2000. And in any event, as I stated earlier, the sole and simple issue before this court is what penalty would the board give with the remaining items left that have not been sustained by Judge Kinney. What would the board do, considering he's on probation, yet he goes on and gets a misdemeanor conviction for the unlawful use of an ID, and secondly, for dishonesty. The judge did not say that those issues were to be relitigated. So the finding stands from the 2011 decision, and with those findings, including the finding of dishonesty, what is the board going to do? And we are arguing revocation mainly for the point of it relates to his judgment and what is a physician's one of his important or her important assets is judgment, decision making. And it's unfortunate that it just appears to be repeated that respondent hasn't been able to demonstrate good judgment.
All right, thank you both. Let me go around the table and see if board members have any questions. Board Member Yip? Board Member Serrano Sewell?
No.
Board Member Bishop?
No, Your Honor.
Board Member Lewis?
No, I did not.
Board Member Yaroslavsky? Board Member Wright? Board Member Diego? Dr. Jackson, Ms. Fay, thank you both very much. We're going to go off the record.